Hello, everyone. I'd like to discuss an interesting topic today, and it's about letters of administration. Essentially, what I want to discuss is if you are married under the Marriage Act and your husband dies intestate when he has children from other women, would your marriage certificate confer any special benefit on you in terms of the management of your late husband's estate? And this topic I'm discussing today is based on my experience over the past 15 years handling various forms of disputes regarding the management of the estate of a deceased person. Most people believe that when you are married under the act, what it simply means is that whenever your husband passes away or your spouse passes away, you have the sole right to determine how his or her estate will be distributed, and you can apply for letters of administration. But this position is not correct, especially where your husband has had children from various women during his lifetime. Ordinarily, what the law says is that when you are married under the act, you shouldn't be able to get married to any other person. But what we found in practice is that a lot of men marry their wife under the Marriage Act. They go to the marriage registry, and after having children with their wife under the Marriage Act, they go ahead to conduct either Sharia or customary marriage with other women. In some cases, they don't even marry these women, they just have them as mistresses or side chicks, and these women give birth to various children for them. And when these men die intestate, you now find that the wives who were married under the act believe that they are the ones who should apply for letters of administration. And in a lot of cases, including cases I've worked on and I've handled, the wives who have the marriage certificate go directly to apply for letter of administration, excluding the other women who had children for the man, or excluding the other children from the various unions or relationship of the men during their lifetime. And what usually happens is if a woman applies for letters of administration because she was married to her husband under the act, the other women who had children for her husband would have a right under the law to file for a caveat. Because yes, whilst it is not appropriate under the law for anyone who has been married under the Marriage Act to have children from other women, this is what happens in practice. So you have to carry them along. So what's the purpose of this video? The purpose of this video is to disabuse the minds of women who are married under the act from believing that when your husband dies, you can apply for letter of administration without carrying along the other children of your husband or the other wives in quotes. Where a man had other women whom he didn't get married to during his lifetime, yes, in applying for letter of administration, you can categorize them as wives and you can carry them along. But if they had children for the man, the law provides that you must carry them along. Because if you don't carry them along, they are going to file a caveat challenging your letter of administration. And if they file the caveat, you won't be able to make any progress. You won't be able to apply for letter of administration. They won't be able to apply for letter of administration. And both of you will now start fighting in court for several years. And when you are fighting in court, what usually happens is that the beneficiaries suffer, the estate depreciates, the value of the estate depreciates. Third parties begin to interfere with the estate, or those who are controlling the asset continue to benefit from the asset because they will tell you that if you don't have letter of administration, we're not going to release the asset to you. So what's a letter of administration? A letter of administration is a document that the beneficiaries of a deceased person apply to from the court. They apply for this document from the probate registry to transfer the assets of the deceased to them, especially in cases where the deceased had no will. So if someone dies and he didn't have a will when he passed away, then the family have to apply for letter of administration before they can have access to his bank account, before they can take over his assets. But if he had a will, then you go for probate grant. So in summary, my message to you all today is that if you are aware that your husband had children from other women during his lifetime, don't believe that you have a special advantage. Yes, you are the wife under the act, but that doesn't mean that you can solely apply for letter of administration without carrying along the other side. You need to compromise. So tactically, strategically, what do I advise? I advise that if you are aware that during your husband's lifetime he had children from various women, before you apply for letter of administration, call them together. The law provides for a maximum of 4 administrators. So even if your husband had children from 5 women and you are the wife making 6 women, Six of you cannot have administrators. So all of you will need to come together and agree on who to be the administrators. And in doing that, don't just use yourself and your children as the administrators. If you do this, you're going to run into problem because you won't get the letter of administration. So what I usually advise my clients is whenever our loved ones pass away, let's look for how we can work together to apply for letter of administration. Let's have our goal on the big picture. Don't chase rats when the elephant is going away. Work together, carry majority along, and apply for letter of administration. Because I've done a case before where my client was married under the act and the other lady had children for the deceased. And when we were in court, the judge said it. We were calling the second wife a mistress because we said under the law she's not recognized as the wife. And the High Court judge mentioned it in open court. I told my clients before we go to court that that was going to happen. And the judge mentioned it in open court that the woman is a wife, even though you are married under the act. And it's not like the judge is not aware of the law. But the customary practice in Nigeria, the woman came to your house, everybody knows her, she has children for you, everybody has accepted her. Then you want to say because you have a certificate, she shouldn't be recognized. It's not done. But what we can now do is that in that situation, those sort of women are not qualified to be administrators. We will push as the first wife who has the marriage certificate. You can advocate and canvass for the position that no other woman should be allowed to be recognized as an administrator, but their children must be allowed. Their children must be recognized. Where they have minor children, then they should be able to nominate someone who will protect their interests. So I hope we all learn from this because if we don't pursue it in the manner in which I've advised, you will see that we end up fighting in court for 20 years, 10 years, and by the time we are done fighting in court, the value of the estate will have depreciated. So the goal for beneficiaries should be that when your loved one pass away, you should be able to have immediate access to their assets within a very reasonable period of time. And if you decide to go alone, you will not be able to achieve your goal. Thank you very much.